Ladies and gentlemen, I think it's very important to know, in particular given what has been instigated by the Prime Minister in respect of the Constitutional Commission doing its work and of course the Constitutional Assembly with the adoption of a new constitution once His Excellency our President assents to the new constitution. Constitutions, in fact, are not just written documents, and I think many people have this belief that constitutions are something that's written, people meet, they agree, they decide, and they write a constitution. In fact, two of the key democracies that we know have unwritten constitutions. New Zealand does not have a written constitution. Neither does the UK, the country that colonized Fiji. They don't have a written constitution. Their constitution is in fact made up of conventions, practices, and in fact tradition. Where do constitutions operate? Constitutions operate in a nation state. But what is a nation state? As was highlighted by our first speaker, his thesis was constitutions are actually imagined. But many books have been written and tell us that nation states themselves are imagined communities. Many of the struggles that we see throughout the world, if you look at Africa, you have probably the most number of right angles in boundaries. Those countries are in fact constructs. They have been created by their colonial masters. So you have borders that actually cut through villages. So one day you were part of one tribe, the next day you belonged in a separate country altogether, whilst your neighbor on the other side of the village belongs to another country now. So nation states themselves, many would argue, are constructs, are imagined communities. But nonetheless, most imagined communities now see themselves as tangible communities that are bound not just by territorial, geographical similarity or likeness or similitude, but also in terms of how they view themselves in relation to the other. And I think that is always very important, because many of the discussions regarding constitutions has been, and unfortunately in Fiji, has been in relation to the other. The Prime Minister alluded to the Joint Parliamentary Select Committee that looked at the Reeves Commission report. And if you look at the deliberations and talk to people who participated, I think there were 14 members, the entire discussions was in relation to the other, which is the ethnic relationship, as opposed to looking at things like the Bill of Rights, whether in fact it was extensive enough or not, freedom of information, public code of conduct, etc. There was very little focus on that. And suddenly when Parliament was constituted in the 1997 Constitution, they said, oh, we actually agreed to this, we didn't realize this. This is why you see that, notwithstanding the fact that you have some very good provisions in the 1997 Constitution regarding freedom of information, regarding code of conduct for public office holders, no substantial law was in fact developed by any of the parliaments under any of the governments that were constituted in the 1997 Constitution. Why do we need a constitution? I think we need to ask that question. Is it because everybody has one, so therefore we should have one? Many would argue simply that the idea of having a constitution is perhaps to protect the rights of individuals against the majoritarianism of the others, or to protect the rights of the individual vis-a-vis the state. The different jurisprudence have developed on that. Different countries take a different approach. This is why it is very important, because to understand our history and the purpose behind developing or writing a constitution. And each country has its own unique experience. The Americans have a minimalist approach. Some may argue they take a very literal interpretation of the Constitution. The right to bear arms is a very important facet of the American Constitution. Some may say it was applicable when they were throwing the British out, and it came from that history. But is it a right that should exist in contemporary society now? There are arguments for and against that. There are many theories, of course. What is the source of those principles and values? Is it simply from practical experience? Or is it a source of principles and values from some higher divine values that may be given to us? Many people would argue that the source of a constitution comes from a moral basis. Morality in that sense means whether it's given through the Bible or the Gita or the Ramayana or the Quran, whatever the case may be. But morality in modern day argument, some would say, comes from the concept of humanism, our relationship with each other as human beings, and that the values and the systems through which we interact are universally acceptable. So this is why you have the UN Declaration on Human Rights. That they would argue that the values that are enunciated in the UN Declaration of Human Rights was something that is universally acceptable. And indeed, it has become universally acceptable. As to how we got to those rights and why it should be applied is obviously something that people would argue. Some would say it has some divine basis to it. Others would say it's got a humanitarian aspect to it, or humanism aspect to it. Therefore, as lawyers, the theory of positive law in a way denies the moral or the divine basis of the formulation of law. But positive law is more to do with the accepted principles and values that a society is able to develop, and the development of statute, the development of jurisprudence, etc., is what we're talking about positive law in the constitutional sense. So the Constitution then becomes the conversion of the moral rights into legal rights. With that conversion, of course, we need to sometimes interpret those legal precepts. This is why the judiciary, therefore, becomes very, very important. What sort of judiciary do we have? What's the approach of the judiciary? And again, I like to use the American example, and that is many Americans would argue that they have the literal meaning of the Constitution. There's certain interpretation that takes place. For example, the Indians have taken a very purposive approach, what they call the purposive approach. That is, the judiciary has decided that the Constitution is there to ensure human dignity, social and political justice, and substantive equality. Some would say that's judicial activism. The judiciary must restrain itself and in fact look at the strict intentions of the constitutional drafters. What did they actually intend? And that's the basis only on which you should interpret the Constitution. In order to, talking about constitutionalism, so constitutionalism from a very simple perspective means placing a higher value not just on the Constitution itself, but the principles and values that are enshrined within the Constitution, giving that primacy. And that is critical, because if you give that primacy, then those principles and values need to be also translated into various arms and facets of government, of the judiciary, of perhaps even civil society, of trade unions, and many other institutions that have an impact on the everyday lives of the citizens living within that nation state. And I think this is perhaps some of the anomalies that existed under the 1997 Constitution, or indeed even prior to that, because we took a very literal view of what the Constitution should be doing or has the scope to apply to. We kind of put the Constitution up there and did not have that translated into the everyday affairs of the nation state. That's where you lose the currency of the Constitution. That's where the currency becomes then some amorphous document that sits up there and which we do not apply to everyday life. So whether you talk about democracy within trade unions, whether you talk about the independence of the judiciary, whether you talk about the independence of a human rights commission, whether you talk about NGOs that may reflect true democratic principles and accountability and transparency. These are all these areas that need to be affected by the Constitution. This is why it is critical that in formulating a Constitution, the participation of the everyday constituents or everyday citizens is critical in the formulation of a Constitution. It must not be led by elites, as the Prime Minister has said. And unfortunately, in Fiji's history, it has always been led by elites. They either have led it or they have ultimately shaped it. Of course, not to mention that for the first time in Fiji's history, in the formulation of a constitution, at least through a commission, you have women present. There's never been women present in any of the constitution formulations in Fiji's history. And we've gone even one step better. Majority of them are women. Out of the 5 commissioners, you have 3 females. In 1968, when they went off to Marlborough House, I think it's 1968, to negotiate on the 1970 Constitution, they was all men. 1990 Constitution Commission, all men. Reeves Commission, all men. Your majority of women. It's a matter of interest. Just to use the phraseology, just in case some of you have social amnesia. Ladies and gentlemen, I think I'd like to leave it from the theory perspective at that. What I'd like to very briefly touch upon, because the 3 of us have decided that we need to have a lot more time for questions, so we're able to then have a healthy discussion. And indeed, it's not just for questions, but for people to even make comments, because this provides a forum, in particular a forum for lawyers, to be able to vent out many of the issues, to be able to understand many of the issues, because going forward within, as set out under the decree, within the next 6 months, you'll have a new constitution. And as the Prime Minister said, by September 2014, there'll be elections under the new constitution. So it is critical we understand, and we are able to understand the critical role that lawyers will play in not just interpreting the Constitution, but actually purveyors of truth, hopefully, going forward. The non-negotiable principles that have been set out under the 2 relevant decrees, if I could highlight that to you: a common and equal citizenry, a secular state, the removal of systemic corruption, an independent judiciary, elimination of discrimination, good and transparent governance, social justice, one person, one vote, one value, the elimination of ethnic voting, proportional representation, and the voting age to be 18. These are principles and values that need to be reflected in the new Constitution, as has been set out under the decree. Now, let me give you a few examples. When we talk about a secular state, it doesn't mean that the state is anti-religious or anti-against religions. It essentially means that the state is a neutral player in the public sphere. Now, the extent of constitutions, or generally the constitutions, are seen to be a public document, and public law is affected under Constitution. New theory, of course, says the Constitution also affects the private sphere, and there has been traditionally the difference between the private and the public spheres in law. But in the public sphere, the secular state essentially means that the state is neutral. The removal, for example, the elimination of ethnic voting, does not mean that there will be legal enforcement on an individual to say you must not vote along ethnic lines. What it says is that there is no legal enforcement of ethnic voting. You, of course, have the choice. You may decide to vote for somebody because you have blue eyes and they have blue eyes. And that's the basis on which you decide to vote. But you are not forced to say that because you have blue eyes, you must therefore choose from people only who have blue eyes. It's a key difference. So, in the non-negotiable principles, a key principle and value is a question of choice, is the principle of choice. You are given the choice. And that when you exercise that choice, your choice and the value of your choice must not be in any way undervalued in relation to somebody else's. That's when you talk about one person, one vote, one value. Those of you who may not know, under the 1997 Constitution, even within the communal seats, the province of Namosi, under the communal seat, had a registered voter population of about 3,200 voters, 3,200, 3,300 voters. They elected one member. The province of Nandrunga, which is where we are, and obviously for very good reasons, had a voter base of 19,000 people, and they voted for one person also. So in other words, the value of the votes of the people in the province of Namosi, to do your mathematics, is about 6 times higher than those of the people in Nandrunga. There are many other anomalies. The 1997 Constitution, for example, the principle behind that the reason why Indo-Fijians were given, or as stated in the 1997 Constitution, Indians were given 19 seats, was because it was in proportion to their proportion in the wider population. But their population numbers had dropped. They in fact should have had about 17 or 16 seats. But the Constitution said only they themselves who had the veto powers could agree to that reduction. Do you think the politicians would have agreed to reducing their own number of seats? And there are many similitudes in other countries. In Lebanon, that's why the government collapsed, because you had various mechanisms based on an assumption that you had homogeneous primordial groups, and they would therefore always continue. But it did not take into account, the Constitution did not take into account demographic changes, socialization, changes in geography, education levels. These are all missed out. And as Ms. Dareva has pointed out, there is obviously a need in the constitution-making process, what we call a deconstruction of our history. It is critical to not just deconstruct our political history, but also our administrative history. Indeed, many would argue we need to deconstruct our very own ideas. I remember as a primary school teacher, I was actually told that Sir Arthur Gordon was a fantastic guy. And in fact, exactly what Ms. Dareva said was that the reason he was a fantastic guy was because he believed in protecting the Itauke people. And what he did, gave them liquor licenses. They could not get out of their villages. If they got out of their villages, they were actually locked up for 7 days. And if you look, those of you who may look at criminal history in Fiji, after World War II, majority of the Itauke people whose population or incarceration rate increased in prison system in Fiji was primarily because of very minor breaches of staying outside the village for more than the 5 or 7 days that they were allowed to get out of the villages. Because as the economy became commercialized and the cash economies, people obviously needed to get out to earn a living. The laws did not keep up with the changes in the demographics. They did not keep up with globalization that had an enormous impact, in particular after World War II in Fiji. Non-negotiable principles like the removal of systemic corruption, independent judiciary, obviously are values and principles that are universally held. Some constitutions may not, for example, specifically spell out for a independent corruption commission provision within their constitution, but others do. It is capturing the value or what is important to that particular nation state at that particular point in time. But indeed, it is a value and principle that has the ability to stay relevant for the length of the Constitution. The decree also has provisions on immunity. And I think we need to be upfront about this issue. The provision of immunity is not a new concept. The provision of immunity is not only unique to Fiji. In fact, the provision of immunity was critical in ensuring the safe passage of a move from an apartheid system to a truly democratic system. That had to be in place, and that was indeed one of the conditions. Yes, there was reconciliation, truth and similar to reconciliation commissions where people could come and talk about what had happened, what they did. But built into that was the immunity provision. Fiji in the 1990 Constitution had an immunity provision, which in fact, many people also overlooked this, social amnesia, that it continued into the 1997 Constitution. So I find it really interesting. There are some people who talk about the 1997 Constitution saying it should be brought back, but in the same breath they say we should not have immunity, even though the 1997 Constitution has immunity or had immunity provisions. So I think it is important for us to realize that these are the realities that we have in Fiji at the moment. That these are the realities in respect of the previous Constitution. And we also need to be able to understand that when you talk about constitutionalism, it has a higher paramountcy, if you like, than the Constitution itself. There are many people, for example, or politicians who believe that once you win office, once you have a majority of seats in parliament, you can do whatever you like. The principle of constitutionalism prevents you from doing that, hopefully. The SDL government had 3 bills. The most famous one was the Reconciliation Bill. Under the Reconciliation Bill, which was in fact considered as a bill by a parliament, allowed for a group of unelected tribunal members to stop judicial proceedings, even though it was in foot. It allowed the tribunal to stop the DPP from carrying out investigations. It allowed the police force to carrying out any further investigations if they deemed it necessary for the purpose of reconciliation. The question, therefore, is a parliament that is elected under a constitution which guarantees the independence of the judiciary, guarantees the independence of the DPP, says that the police must be allowed to carry out investigations, is the very same parliament that is in fact undermining the constitution itself. The question that we all need to ask is, what are the safeguards? Are the parliamentarians, are the politicians themselves adhering to the principles of constitutionalism, which is a much higher, or has more primacy than the written constitution itself? Ladies and gentlemen, I thank you for your attention, and we look forward to your questions. Pinaka.